All right, thank you, Chairman. Sorry about that. I had to get situated. Appreciate the opportunity to visit with the Rules Committee today and offer an amendment to the legislation, which mirrors the amendment and the legislation that was offered by my friend Senator Mike Lee in the U.S. Senate. It is something that I believe is extremely important, that we have the ability to debate in the United States House. We have not had any hearing in the United States House, in the House Judiciary Committee, on this bill or on this amendment or the ability to debate it in full. We rushed this bill through in July, allegedly in some sort of emergency setting because of some words that Clarence Thomas penned. And so it was an emergency that we passed this in July. It clearly wasn't political. It was an emergency. And here we sit having no debate in the United States House Judiciary Committee, having had no serious debate on the floor of the House. And here we are again, about to have no serious debate in the House Judiciary Committee or no serious debate on the floor of the U.S. House. It'll be another perfunctory exercise in this body where we bring forward legislation that has enormous consequences, where we drop it on the floor of the House, and we say vote up or down, and then go give speeches. And that's what we'll do, and we'll jam it through. And this is why the House of Representatives is badly broken. So I'm going to offer the amendment. I know the result. You all know the result. It will get not only either voted down, I'm told it's going to be ruled out of order because it apparently has some, it is said to violate, I think, Rule 10A or whatever it is with respect to having an impact, and allegedly that has an impact with respect to deficits. As I read the rule, what I saw out of the CBO was that it would raise revenues but also have expenditures, but it doesn't actually say anything about having deficits, which is what the rule actually says. But I would only say to the committee that there is only one way that this could technically violate said rule is if it's effective. That's the only way, is if the amendment is adopted, is effective, and actually has damages as a result of the AG taking action and people bringing suit and getting damages. It's the only way that it can actually have a cost that would raise deficits. So think about that. We're going to block an amendment because it technically violates a rule with respect to deficits because it might be effective. I offer the amendment for a variety of reasons. Right now, as we know, the legislative branch has been neutral on the issue of same-sex marriage, at least as in terms of its stated position. Obviously, we have the Obergefell opinion. This bill barrels us into the space that's not actually being threatened, in my view. Obviously, my colleagues think that this is necessary because of the words penned by Justice Thomas. I heard my friend from Maryland discussing that it was necessary. But the reality is what Justice Thomas said was more questioning how the rights came into being, not the what. Justice Thomas, in fact, brought up the fact that it could be privileges and immunities instead of substantive due process. He brought up another number of ways he could get there, and this is hardly anything new by something that Justice Thomas has put out in his jurisprudence and his doctrines previously. This bill, as amended, in my view, does not adequately protect people who have closely held religious or moral beliefs from going about their own lives. In my view, for example, Section 6, which one of the members of the committee brought up as having offered some significant protections, is basically just stating a truism, that the Constitution exists and RFRA exists. But it does nothing to actually, in the end, protect all Americans from the sword that is being provided in this legislation. And I would also offer and remind the committee that this body passed legislation off the floor that did not have any of these religious liberty protections that the Senate added, which are limited and do not actually cover the gamut of the religious liberty that needs to be protected. The fact is, the House rushed it through with no hearings, sent it over with no religious liberty protections in the legislation, and still had the sword of the private rights of action. Kicked it to the Senate in a rush. The Senate then adds in, I think, half protections. And now, instead of having a robust debate here, perhaps going into the House Judiciary Committee and having a robust debate about how we could ensure protections for everybody, we're going to have it killed here on a technicality and, frankly, on the substance, even if it weren't for the technicality. and we won't even have a debate on the floor of the House for a full measure of robust religious liberty protections. In what universe is this the way we should be doing business? Indeed, people with closely held religious beliefs are not actually protected by this bill, in my view. It does nothing to protect, for example, Lori Smith and the 303 creative case that are being argued right across the street today in the United States Supreme Court. Jack Phillips, known as the cake baker from Colorado. Dr. Andrew Fox in Austin, where I live, a volunteer fire department chaplain who was fired from a volunteer position for volunteering his views about traditional marriage and or about gender roles and boys swimming against girls, for example. We've seen the effects of laws like this in Finland, where a member of the parliament, Päivi Räsänen, a member of the parliament, was dragged through a court for sharing her beliefs about same-sex marriage 20 years ago on a pamphlet. This is coming to a theater near you, ladies and gentlemen, and this legislation, supposedly with religious liberty protections, is going to be the sword that is going to come after you. Because notwithstanding what my friend from Maryland just opined, it does not provide the robust protections that are necessary to ensure the full protections of the First Amendment to which we are due as citizens in this country. In fact, not only are these people not protected from the effect of the bill, but they will actually be targeted under this bill by trial lawyers in the Attorney General's office. Section 4B allows the AG to bring suit against any person who violates a right or claim rising from such a marriage while under the color of state law, a not defined term, and arising from such a marriage. What does that even mean? Section 4B allows any person to bring suit against another person for the same, even if people with religious beliefs had a suit brought against them and they won on the merits. We often see long and expensive suits ruin businesses and lives in the process. If we actually want to protect everyone's First Amendment rights, I believe we must pass the amendment that I'm offering here today. And if you think this amendment is superfluous, there's no reason not to put it forward for a vote and let the body decide. I don't see what the harm is in offering legislation and offering an amendment which would expand protections for religious liberty if our concern here, as the gentleman from Maryland said and others, is that we want to ensure that we've got protections for religious liberty. I appreciate the chairman giving me the time here today. I know it's late in the day because there was a longer panel, but I cannot for the life of me understand how we're going to take up such an important issue and never having gone through the House Judiciary Committee before actually debating it and now offering an amendment that is worthy of debate to ensure full protection of religious liberty for the American people and not have the ability to actually debate it here, frankly, even in rules, because it's going to get killed on a budget issue. And with that, I will yield back to the chairman.
Well, thank you very much. We appreciate you being here. I personally believe your amendment is duplicative and unnecessary, but he's correct. The gentleman's correct when he says it violates at least one budgetary point of order. And the point of order ruling is not something that we've come up with out of the air. It comes from the parliamentarian and from CBO. You know, the Senate spent months crafting a bipartisan compromise to amend H.R. 8404 to address the religious liberty concerns raised by Republicans in the House and Senate. Sections 6 and 7 of the legislation ensures that there's no impact on religious liberty. And I think if we would have, which I think we're not going to do because it does violate a point of order, but I think it would unsettle the Senate's carefully crafted compromise. It would obviously probably derail action on this bill. And the gentleman said, he maybe wasn't here when at the beginning of the previous panel, but he said, oh, we acted like it was an emergency. Absolutely. You know, when you're faced with a Supreme Court, many Republican judges who assured time and time again, Democratic senators and Republican senators, that Roe versus Wade was was established precedent, and then they turn around and basically take away a women's right to choose and obliterate 50 years of what it was established law in this country. And then when you have Clarence Thomas opine about marriage equality, you bet your life many of us think that this is an emergency. Many of us think that the Supreme Court is working overtime to try to turn back the clock. on so many rights. So, yeah. But if the House passes this legislation, which I expect and hope that it will do, it will go right to the President's desk and become law. And there are millions of people in this country that will have the peace of mind knowing that it has become law. And so I think that, this House has gone through both, this bill has gone through both the House and Senate. I believe it needs to be signed into law as soon as possible. And without objection, I'm going to ask unanimous consent to insert into the record letters in support of this legislation from the Interfaith Alliance, U.S. Jewish organizations, and from 8 leaders of faith-based organizations representing tens of millions of Americans and hundreds of religious institutions. And I'm happy to yield to the gentleman from Oklahoma.
Thank you very much, Mr. Chairman. I just want to associate myself with my friend from concerns about process here. He's exactly right. We didn't debate the last version of this bill, didn't go through committee. We're not doing this version of this bill. We passed the one in July because it was quote-unquote an emergency, but evidently it wasn't because nothing's happened and that bill isn't becoming law. We have something different. It's better, and the only reason, why it's better? Because it actually went through something of a process over there. Our process is not that one house draws something up and the other house accepts it. Both houses look, and then we go to conference, and then we have a better product. So we've seen a lot of that this Congress, and I regret that very much because I think it destroys people's confidence in the process itself and their belief that all points of view are going to be considered and you'll have a thorough debate. But again, that's my point of view.
Thank you.
Would the ranking member yield?
Certainly yield my friend.
I would just ask, and I will send it to staff, there's a list of 83 groups from Alliance Defending Freedom to the Billy Graham Evangelistic Association, to Concerned Women for America, a host of religious organizations, a host of church organizations and religious organizations, 83 of them that have expressed concerns that this would trample on religious liberty rights. I'd like that inserted in the record.
Appreciate that.
And I'll say without objection.
Yeah, thank you, Mr. Chairman.
Mr. Perlmutter.
No questions. Thank you for your testimony.
Dr. Burgess.
And I appreciate the gentleman's testimony as well. I appreciate you referencing the concern I had over Section 6 in the bill and the concerns brought to me by Family Research Council. Mr. Chairman, I'd just point out that we are the all-powerful Rules Committee, and we can waive points of order.
Of course.
We do so with regularity. I dare say we're going to receive the text of a rule here in a few moments that will waive some points of order. So it is certainly within our power to waive whatever budgetary point of order there is and allow the robust debate that Mr. Roy seeks. And here's the thing. The letter that was sent to us by Chairman Nadler of the Judiciary Committee asked for a closed rule on a bill that never had a hearing in the Judiciary Committee, passed the Rules Committee under an emergency procedure earlier this year, and now many months later has come back to us from the Senate. Why would you have a closed process for this? If nothing else, we should have a structured rule, allow debate on what Mr. Roy has.
Would the gentleman yield? I'll explain to you why. Because if we were to amend this and it goes back to the Senate, for all intents and purposes, it's dead for the year. And many of us believe that we have a court right now that is hell-bent on trying to reverse the rights for the LGBTQ community, and we do not trust them to respect the marriage equality in this country. So that is why. So that's where we're coming. When in January comes along, the gentleman's party will be in charge, and you can bring one amendment after another to reverse the last 70 years of social progress, if the gentleman prefers. And we will oppose you on that.
Reclaiming my time from the chairman, there's no evidence of the Armageddon that he describes being at the doorstep. But Mr. Roy, you looked as if you wanted to say something.
Well, I would just say, if the amendment is unnecessary, then it will fail on the floor of the House, and you have no concern about bouncing it to the Senate. If the amendment is important and would pass on a bipartisan basis, by the way, it was a bipartisan amendment in the Senate, and it was a close vote in the Senate. It would be important for the People's House to express its will of full protection of religious liberty for the people of the United States on such an important issue as marriage, and as expressing religious liberty and the ability for people to speak freely about it. Again, I reiterate, a member of parliament was prosecuted in Finland for a statement made in defense of traditional marriage made 20 years ago. Is this where we're headed? Is this the direction that this country is going? Because if it is, we're going to be shredding what little there is of the fabric holding us together in a union in which we can agree to disagree. And the fact is, the amendment is offered in good faith, as it was by my friend from Utah, Mr. Lee, and was, of course, voted down. It did have bipartisan support, acknowledged. And I think it would be an important amendment to just offer on the floor of the House. You know how it'll work. We'll get an hour of debate on both sides. The amendment will almost certainly get voted down, but I hope it wouldn't, because I believe it's important. I'd like to have at least the opportunity in the 1 hour of debate that I would get in this august body to be able to make the case for religious liberty with my colleagues. I yield back to the gentleman from Texas.
And I thank the gentleman. Mr. Chairman, I also have a couple of unanimous consent requests. One is I referenced the schism in the Methodist Church in Texas, and I'd like to submit for the record this article from the Texas Tribune.
I won't object to anything you want to insert in the record.
I'd be happy to read it, but,
I'm giving you the courtesy of,
and then earlier I referenced a New York Times article about the Disney visa layoffs, and I would also ask unanimous consent. I didn't earlier, but I'd ask you.
Without objection.
Both those be part of the record.
without objection.
Thank you.
Mr. Perlmutter, you have? Okay, I'm sorry, okay, Ms. Torres, okay. Ms. Fishbach?
Thank you, Mr. Chair. And I just wanted to, I guess, associate myself with the remarks of my colleague from Texas in particular, and I think Mr. Cole expressed it also as the issues with the process. This is a important piece of legislation to the majority, and that they would push it through like they did without having any kind of input from the members of the House of Representatives seems like a bad way to handle something if you see it as so important. And you know, I think that when we talk about whatever it was in July, that it was an emergency.
Yeah.
You know, cases have to appear before the court can make a decision, and that takes months, years, very long time to get it there. So I don't see that there was an emergency. There wasn't something sitting in front of the court that they were going to be deciding on. And so I think that that's a little bit, you know, overstated when you say it was an emergency. And I really am concerned, and I think we've said this repeatedly in the Rules Committee, is the process has been horrible. Just over and over, things being rammed through. And I have concerns, and I think that, you know, Mr. Roy has a valid argument, says give him an hour to argue it on the floor and let the body decide. And with that, I will yield back.
I have a good idea. I'm not sure who's going to handle the rule on the Republican side, but they can yield you the entire half an hour to make your case, if you want to do that. And I'm sorry that I'm sorry that
For an amendment that's not in order?
well, I'm sorry that my friends don't think this is an emergency. I have constituents that think it's an emergency. They, quite frankly, are frightened out of their mind by the behavior of the Supreme Court after the Dobbs decision. And so, look, I mean, this may not be a big deal to some of my friends on the other side of the aisle. I assure you it is a big deal to many of us on this side of the aisle. Mr. Raskin.
Thank you, Mr. Chairman, and it's a pleasure always to see my friend from Texas, Mr. Roy. And I wanted to just ask a couple of things. One is, you know, he posed the question of whether we're headed in the direction of Great Britain, where he reports a case, which I'm unaware of, about someone being apparently prosecuted or punished for, I don't know, anti-gay speech or something. I don't know what he's referring to there, but I can guarantee you that there's nobody who has been prosecuted for saying that they're opposed to the Obergefell decision or they're opposed to same-sex marriage. That's perfectly covered by the First Amendment. In fact, you could say you're opposed to our whole Constitution, which Donald Trump said yesterday, I think, and that's completely within his First Amendment rights. Of course, you can't incite a violent insurrection against the government as President of the United States, which is moving from speech to action, but he's made himself clear that he's opposed to the Constitution of the United States. But so I don't know whether there are any American cases Mr. Roy, that you were referring to, but if there is one, I would love to hear about it. I would be far more reassured by our colleagues who keep telling us, like Mr. Burgess, not to worry about the Armageddon of the Supreme Court overturning the Obergefell decision and trying to strip away the right of gay people to get married in America, if they also told us they were opposed to that. But it seems like the people who keep telling us not to worry about Armageddon are the same people who are trying to make Armageddon arrive. So if any of them would say, well, don't worry, Justice Thomas didn't really mean it, or he doesn't have the kind of influence with Alito and the other justices that we think he has, but in any event, I'm with you in standing up for Obergefell, then I could feel a little bit better. But I'm not going to accept assurances from people who are working to overturn the right of gay people to get married in America. But I wanted to ask my friend, Mr. Roy, this question, which I thought was so interesting in the beginning, when he seemed to concede that his amendment violates PAGO, and therefore what he describes as a technical budgetary threshold issue in trying to become an amendment. And then, but then he says, well, the only way it would violate is if the amendment works. But isn't that always the test? Isn't that always what we ask ourselves when someone offers an amendment? If this amendment works, would it violate the underlying substance of a rule? So why is that in any way unusual?
Well, but my friend from Maryland, I appreciate the question on that one. First of all, I did not concede that. I conceded that the CBO simply said that there would be revenues, fees, and potential expenditures, but that those expenditures would be tied to success. Meaning success, meaning you created a law and a framework under which American citizens were able to go get damages because the AGs were out of bounds and they won their suit. They won their case. So my point is just not that there isn't potentially a financial impact. I think we're all pretty well aware of my concern about financial impacts when we have bills on the floor. If this were a suspension vote, I'd have concerns about having a cost that's just thrown down on the floor. But I'm saying here, you have the ability as the Rules Committee to make a decision. And, to say that $500,000, it could be more, guess by the CBO, and to then kick this out based on the fact that you would have the successful reality of getting the damages is insane. Like, that's the whole point. If we think it's garbage and it wouldn't work, then it wouldn't cost a dime. Literally.
All right. Okay, I got you. I got you on that. Let me ask you one final question, which really gets to the heart of the matter, because we seem to have a very different concept of what religious liberty and freedom is. And mine is very influenced by Madison's views as he expressed them in his memorial and remonstrance against religious taxation. And it's about the right of people to worship freely, to pray freely, not to be harassed and persecuted for their religious free exercise. But it's not a right to discriminate in public against other people. In fact, if you go back and you look at the major civil rights cases from the 1960s, the motel owners and the hotel owners and the restaurant owners who wanted to discriminate against Black customers also shrouded their intent in the language of religious freedom, saying, well, it violates our religious principles to serve African American customers, or we don't want to have interracial couples staying at our hotel because that violates our religious precepts. But the Supreme Court determined that when you enter the stream of commerce, you are providing a public accommodation with all of the benefits that you get from society in doing it. You do not have a religious free exercise to discriminate. Your church can discriminate. If your church wants to exclude people of different religions, of course, or different races or ethnicities or interracial, interfaith couples, they can do that. That's what the religion can do. But if you set up hotels and restaurants and office establishments and so on, no, you don't have a right to discriminate against people based on race, religion, ethnicity, and sexual orientation. And I'm just wondering why you think sexual orientation should be different from any other category of discrimination. And I hope you would recognize that people who've wanted to discriminate have always tried to wrap their discrimination in the guise of exercise of their religion. And you're free to comment or not, as you see fit.
Sure, no, happy to. And again, I appreciate the question and always enjoy the give and take. I wish this were in the House Judiciary Committee and we could do it at length. Two things. Number one, with respect to the question, I'm glad the gentleman acknowledges, which is the very truth that's driving my wanting to offer the amendment, which is the protections offered around which my 12 Republican colleagues in the Senate base their support are highly limited, as the gentleman from Maryland just acknowledges. Highly limited to, for example, the word, it's the solemnization, it's the act, it's within the church, it's the act of the marriage, of the action of the pastor or the priest or the bishop. It's not to the more expanded view to answer the question of whether or not, for example, the school that my children go to, or that many other folks' children go to, that might be a religious-based school, can you discriminate? Can you make a choice to not hire somebody that's engaged in a same-sex union at your children's school? I mean, that's a debate. That's a question. It's a question whether is this going to be protected or not protected. And I think that's the debate that I would like to flush out, right? That's part of what we're trying to get at. And then the second thing, to answer your question, I realize that there's often the effort to put this together with the issue of interracial marriage. And I understand. I would associate myself, much to the chagrin, no doubt, of many on the committee, with Justice Thomas's footnote 5 from Obergefell, in which he said, the suggestion of petitioners and their amici that anti-miscegenation laws are akin to laws defining marriages between one man and one woman is both offensive and inaccurate. America's earliest laws against interracial sex and marriage were spawned by slavery. For instance, Maryland's 1664 law prohibited marriages between freeborn English women and Negro slaves was passed as part of the very act that authorized lifelong slavery. Virginia's anti-miscegenation laws likewise were passed in 1691 resolution entitled An Act for Suppressing Outlying Slaves. I will save the rest to say that he goes on to say, the traditional definition of marriage has prevailed in every society that has recognized marriage throughout history. It arose not out of a desire to shore up an invidious institution like slavery, but out of a desire to increase the likelihood that children will be born and raised in stable and enduring family units by both the mothers and the fathers who brought them into the world. Final point being, and it has existed in civilizations containing all manner of views on homosexuality. I yield back to the gentleman from Maryland.
Just to interrupt on that second, of course, if you go back and read Loving versus Virginia, you will see that the dissenters wrap their objection precisely in millennia of moral teaching and moral objections under traditional marriage to making Virginia, compelling Virginia to allow black people and white people to get married, or to allow white people to marry outside of the white race. So I think that the court in Obergefell made exactly the right analogy. All of this is about some people judging other people's marriages and then trying to use the state to interfere with their ability to marry the person they love. With that, Mr. Chairman, I'll yield back to you.
Thank you.
All right, I yield back.
Thank you very much. Any other questions? No other questions. You're free to go. Thank you very much.
I thank the chairman.
You two ought to teach.
Are there any
class
other members
together.
who wish to testify on Senate Amendment to H.R. 8404, the Respect for Marriage Act, H.R. 3648, the Eagle Act of 2022, and H.R. 7946, the Veteran Service Recognition Act of 2022? Hearing none, seeing none, this closes the hearing on these three measures.